Hi. Good afternoon and welcome to everyone. As many of you know, my name is Dan Attridge. I'm the dean here at the law school. It's my pleasure to welcome everyone. Today's lecture is part of our Saint John the 23rd lecture. It's the first time I've been able to say Saint John. Up until now, it's been Pope John the 23rd, which began at our law school all the way back in 1965. This lecture series, like our Brendan Brown lecture series that many of you are familiar with, is one in which we invite outstanding professionals from various fields who've made a contribution to public life to share their perspectives on a wide variety of current topics. I won't take you through it, but on the back page of your program, you'll see a list of the prior speakers in this series. Our speaker today is the Honorable Brett Kavanaugh. Since the year 2006, Judge Kavanaugh has been serving as a judge on the United States Court of Appeals for the District of Columbia Circuit, often referred to, I know Judge Kavanaugh's heard this, as the second most important court, not just in the District of Columbia, but in the United States. Before his appointment, Judge Kavanaugh enjoyed a distinguished career both in the public and private sectors. Among other positions, he served as an assistant and staff secretary to President George W. Bush, as an associate counsel in the Office of Independent Counsel of Kenneth Starr, as an attorney in the Office of the Solicitor General of the United States, and he was also my law partner at the firm of Kirkland Ellis. Judge Kavanaugh is a graduate of Yale College and Yale Law School. He's taught as an adjunct professor at Harvard Law School and the Georgetown University Law Center, and he has argued cases before the Supreme Court, U.S. Courts of Appeals, and other federal and state courts. More details about his extensive background may be found in your program. Judge Kavanaugh will be speaking today on the topic of the judge as umpire. It is a topic that he obviously knows quite well, not only from his current perspective as a sitting appellate judge, but from his prior experience as an advocate in both the private and public sectors and as a law professor. We are quite fortunate that he is willing to share his expertise and thoughts with us today. Please join me in welcoming Judge Kavanaugh.
Well, thank you, Dean Attridge, for that generous introduction. It is a great honor to be here at Catholic University, this distinguished university and distinguished law school, whose mission it is to help others, to serve others. That's one of the stated missions of this law school, to care for the poor and the neglected and the vulnerable. And I know this university and this law school stands for that and does it so well. And this school is proud, of course, of its Catholic heritage. I myself am a product of Catholic schools in this area. I grew up in this area, one of the few judges on the D.C. Circuit who grew up in this area, and I went to Modern Day in Georgetown Prep. And our motto at Georgetown Prep was to be men for others. It was an all-boys school, to be men for others. And I know this school helps teach its students to be lawyers for others, to serve the public and to serve others who are in need. And I remember from my education, the teachers and coaches, their voices still ring in my ears. Father Byrne, who was this classic Latin professor and was about this tall, and he was always telling us these things that still I can remember so well today about be prepared, you can't go wrong as you go along if you are prepared. And he had all these slogans. And Mr. Fagan, our football coach, I can still hear him kind of yelling at us to do things better and to do things the right way at all times. And the lesson I draw from that education to the teachers and professors who are here and to the educators who are here, your lessons are heard, not just in the classroom, but years later as they influence the students at this distinguished law school and distinguished university. And we all thank the professors, the teachers, the educators who are here at this school and teaching the future generations of lawyers. By coincidence, 3 classmates of mine at Georgetown Prep were graduates of this law school in 1990 and are really, really good friends of mine, Mike Bidwell, Don Ergo, and Phil Merkel, and they were good friends of mine then and are still good friends of mine as recently as this weekend when we were all on email together. But fortunately, we had a good saying that we've held firm to this day, as the dean was reminding me before the talk, which is what happens at Georgetown Prep stays at Georgetown Prep. That's been a good thing for all of us, I think. I think the dean, a wonderful man. He and I worked together at Kirkland and Ellis, and we had memorable cases and lawyers at Kirkland and Ellis. And I think back at those times, and one person comes to mind that we worked with was a guy who was a little younger than I was, named Ted Elliott. And Ted was a great lawyer, a great guy, and he worked with us at Kirkland. Then when I was at the White House and became this job called staff secretary, I had to hire a deputy, and Ted was a great lawyer, and I brought him in as my deputy. And then I went on to be a judge, and I remember getting a call from him in 2007 or 2008, and he said, yeah, I'm going to go take this job in California. I was like, oh, wow. Doing what? So I'm going to be general counsel of this company, and I'd never heard of the company he was talking about. It was general counsel of Facebook. And that turned out to be a really good move. And I spent, I am committed to public service, as I said, but I do spend some time reading Robert Frost, The Road Not Taken. Now, well, we are here at a lecture series named for a pope, and I will say the pope I know of the best, Pope Francis, of course, the current pope, but Pope John Paul II, when I worked at the White House, one of the great highlights, maybe the singular highlight of my experience working at the White House was traveling with the president all over the world and all over the country with President Bush, but then traveling to the Vatican in 2004, and President Bush was going to meet with the Pope and to award him the Presidential Medal of Freedom, which is the highest civilian honor of the United States. And you've probably seen this ceremony at the White House, where the president has many distinguished Americans or world leaders, and he puts a little medal around their neck and gives a speech about all their contributions to the United States and how they've been friends of the United States. So we were doing this at the Vatican, and President Bush said, well, we're going to be at the Vatican. The staff secretary, I was in charge of stuff no one else wanted to do, was one of my things that I had to do. I'm not going to stand up at the Vatican and put a medal around the Pope's neck. How are we going to accomplish this? I said, it's all under control, sir, which it wasn't, which is what you say, and then you make it under control. And so we had this box, and this box with the presidential seal really looked good, and the medal was kind of nicely in front of the box. And I still remember at the ceremony, this thing, logistics, what can go wrong? And so the president had the box on a little table, and he's speaking about the Pope. And then first he's fiddling with the box. Oh my God, the box is not going to open. And it lasted all for 1 second, but it felt like a lifetime. The box isn't going to open. Then he hands it. He reads the citation, which I'll mention in a minute, and he reads it to the crowd and hands it to the Pope. And the Pope he was pretty frail then. He holds it up, and in my memory, it's upside down, but in reality, it was just holding it up. But I was thinking there and sweating. The medal, what if the medal falls out? What if the medal falls out of the box? My career is over. In that moment of sheer panic, kind of thinking ahead through everything. But it was a great ceremony, and the Pope concluded it by saying, "God bless America." And I think he was such a great example of someone who stood for principle in the face of tyranny and changing the world, and a model for all of us. And that was I think that people say, what was the greatest experience you had at the White House? And there were so many to think about, but that really stands out as the product of the Catholic education, to be there in the presence of the Pope, and for the medal to actually stay in the box. Perfect. Now here, I'm here today to talk, and I want to have a conversation and questions about judging. And I've been doing that for almost 9 years now, and on the DC circuit. And the dean said it's sometimes referred to in a particular way as how important it is in the judiciary as a whole, and that's usually by judges who are on that court who refer to it that way. But it is one of the many courts of appeals. They're the first through the 11th Circuit, then the D.C. Circuit, and the Federal Circuit. And we do hear a lot of constitutional and administrative law cases that do have national significance, which is the distinctive quality, I would say, of our court. But I want to talk about this notion of what judges do, and judges as umpires. And Chief Justice Roberts really captured this at his confirmation hearing, and by referring to this concept, what kind of judge are you going to be? What kind of justice are you going to be, John Roberts? And he gave this great description of being an umpire. No one ever went to the game to see the umpire. And a few things about that. First of all, for the students who are here, the lawyers who are here, what a great way to capture something in a very simple explanation, right? What a great way. And that's one of the goals of being a great lawyer or being a judge, is being able to capture some complicated, very difficult principle in a very succinct and persuasive way. And John Roberts had no peer as an advocate and really captured it well in that confirmation hearing. But of course, that notion, the notion that judge is just an umpire, has been criticized by those who say, well, judges are really just politicians in robes. Judges are really advocates. They're partisans. They're not just umpires. And I think this reflects, in my view, a misapprehension of what a judge is, also a bit of a misapprehension of what an umpire does in baseball, or a referee does in football or basketball as well. Now, at its core, to be an umpire as a judge, I think, means to follow the law and not to make the law, and to be impartial in how we go about doing that. And I would say at the outset, it has to be the idea of being someone who just follows the law and doesn't make the law, who is impartial. That has to be our aspiration. It has to be our goal. And we can talk about the limits of achieving that goal, that objective. But I think it has to be our aspiration in a system of even-handed justice, in a system dedicated to the rule of law. So how do we do it? How do those of us who want to be umpires, who want to be judges as umpires, how do we do it? What are our habits? What are the attributes that we're seeking to achieve? And I'm going to go through a few of them and how we try to do it, how I try to do it, and I'll say right away, I know I fall short. I know all of us fall short at times, but that doesn't mean this isn't what you should be striving to try to achieve. And let me run through what I think a judge as umpire means. First, and probably most obviously, not being a political partisan. We often come from backgrounds, judges often come from backgrounds where we had involvement with politics, with policy. We want people in our judicial system who understand how the government works, who've been involved in government. That's the difference between our system and judicial systems in other parts of the world, where we come from the private practice of law, we come from the executive branch, we come from the legislative branch. The model, of course, Justice Robert Jackson, who was Attorney General, really the model for all judges who have come from the executive branch in terms of being able to transform from a great executive branch lawyer to a great justice. Chief Justice Roberts and Justice Kagan both worked in White House. Justice Breyer was a Senate staffer for many years. This is commonplace in our system to come from that background. But you have to check those political allegiances at the door when you become a judge. You have to shed them. We no longer can contribute money to political campaigns. We don't participate in partisan campaigns. We don't attend rallies. We don't endorse candidates. Some judges go and don't even vote on the theory that to vote is an expression, at least to yourself, of your political affiliation in a particular case. Justice Harlan, for example, when he was on the Supreme Court, chose not to even vote. You can be a spectator. You can still watch the game from the sidelines, but you're not participating in that political world anymore. So it's very important at the outset for a judge who wants to be an umpire to avoid any semblance of that partisanship, of that political background, of that background they might have had in a particular line of work. That's the first, probably most fundamental thing for a judge who wants to be an umpire. Now, to be a good judge and a good umpire, you also have to follow the established rules and established principles. You don't make it up as you go along. An umpire shouldn't be making up the strike zone as he goes along, right? Judges shouldn't be making up the rules as they go along either. And so we see this in statutory interpretation, for example. A good judge sticks to the established text and canons of construction that help guide us for interpreting ambiguous text. Justice Scalia, of course, has had a profound influence on statutory interpretation. And one of the things he's helped to do, and you see this from judges of all supposed ideological stripes, is he's narrowed the areas of disagreement about how to interpret statutes. Every judge now seems to start with the text of the statute. If you came to our court and sat and listened to cases, say, for a week, and I don't advise this, but if you came and sat in our courtroom for a week, you'd hear every judge of all supposed ideological stripes saying, but what does the text of the statute say? Where does the text of the statute support your position? That's been a big change in statutory interpretation and has helped narrow the areas of disagreement in statutory interpretation. Stare decisis, we follow the cases that have been decided. We operate in a system built on precedent of cases that have been decided by the Supreme Court. We have absolute vertical stare decisis, meaning we follow what the Supreme Court says. And to be a good judge, I think it has to be in letter and in spirit to follow the Supreme Court precedent. It's not trying to wriggle out of what the Supreme Court said or try to twist what the Supreme Court said or to push the law in a particular direction, but to follow what the Supreme Court said in letter and in spirit. To be a good judge and a good umpire, you have to display, I think, humility and modesty. And Chief Justice Roberts referred to being a modest judge in his confirmation hearing. What does that mean? It means a lot of things, I think. A lot is captured under humility and modesty as a judge. First of all, we're not to make the policy ourselves. That's obvious, but we constantly have to remember it's not our job to make the policy choices that belong in the political branches. We have to recognize our more limited role. It's an important role, and it can be a decisive role on important matters affecting our system of government, but it is a more limited role. We're not the one designing the rules and making the policy choices in the first instance. It means having an open mind. It means a willingness to change your mind. That's something that judges have to do, to say, well, I didn't look at it that way a few years ago, but now I see that it looks different to me, and having that willingness to be humble about it and to change your mind. To keep learning. We do not know it all. I know some judges sometimes, if you're in a courtroom, it appears that the judge thinks he or she knows it all. Judges have to remember we do not know it all. We have to constantly be learning, to draw from the law reviews and the treatises that professors have worked on for years to study a problem that we may have a couple of days to focus on. To remember that we're not the font of all wisdom. And if you need an extra dose of humility, just walk down in our courthouse a side hallway that has portraits of all these judges who served 40, 50, 70 years ago. And I challenge any judge to name a single person on one of those portraits. It's called the Hall of Humility in our courthouse, because you've heard some of the names, but when time passes, right, our contribution as well, you're not going to be remembered forever, and to remember that we have a limited time and a limited role and a limited place is important. To be a good judge and a good umpire, it's important to have the proper demeanor. Really important, I think, to walk in the other's shoes, whether it be the other litigants, the litigants in the case, the other judges, to understand them, to keep our emotions in check, to be calm amidst the storm. On the bench, to put it in the vernacular, don't be a jerk. I think that's important. To be a good umpire and a good judge, don't be a jerk. And in your opinions, to demonstrate civility. I think that's important as well, to show, to help display that you're trying to make the decision impartially and dispassionately based on the law and not based on your emotions. That we're not bigger than the game. Sometimes you hear coaches complain about umpires or referees. He or she thinks they're bigger than the game, right? We can't be bigger than the game. We can't act like we're bigger than the game. There's a danger of arrogance as for umpires, for referees, but also for judges. And I would say that danger grows the more time you're on the bench. As one of my colleagues puts it, you become more like yourself. And that can be a problem over time. And so constantly to be guarding against that arrogance, that idea that you know better than others. Really important for umpires and judges. To be a good judge and a good umpire, you have to tune out the crowd noise, right? Criticism of umpires and referees, and I've reffed basketball games, and even in fourth grade basketball, there's a lot of crowd noise directed at the referees. And so too with judges, right? There's a lot of criticism of judges' decisions in the media and on blogs after they've been made. Sometimes there's even working the ref before the game is played, working the judge before the game with tweets and blog posts and trying to put implicit or sometimes explicit pressure on judges. You see that sometimes statements from politicians doing this or commentators doing this. And you see this, of course, in basketball. Coach K, of course, legendarily at coaching, but also pretty good at working the refs during the game, if you watch. We have to tune that out. We have to tune out the crowd noise. We can't be buffaloed, influenced, pressured into worrying too much about transient popularity when we're trying to decide a case based on long-term principle that is at issue in a particular case. We can't just rule for the most popular side. One of the most important duties of a judge as an umpire is to stand up for the unpopular who has the correct position on an issue of law in a particular case, to be willing to defend the person who is unpopular in a particular case, stand up for the unpopular position. We need to be able to tune out the crowd noise. At the same time, just to put a cautionary note there, we can't tune it out so much that when we're not willing to learn from our mistakes, to learn from informed commentary. So there is a balance there, but tuning out the crowd noise, but remembering that we're not perfect, far from it, and that we have to learn over time from those who, in good faith, critique and analyze our decisions. To be a good judge and a good umpire, I think, especially on an appellate court, you need collegiality, learning from your colleagues. We're collective bodies. I can't do anything alone. As my district court colleagues remind me, since they sit by themselves, you are powerless to do anything by yourself. They like to say that to appellate judges, and it's true. We can't do anything by ourselves. We work in panels of 3, so we have to be working together with the other judges to try to produce the best decision. This group decision making helps reduce errors. It helps check subtle biases that might creep into how you decide a particular case. You see umpires sometimes huddle, or the referees huddle a zebra conference in a game where they get together to talk about whether they made the right call. Well, we have a zebra conference in every game. That's what we do. We get together and work together in panels. And to do well at that, we have to work well with others. We have to play well in the sandbox with our other judges to be a good judge and a good umpire. To be a good judge and a good umpire, you have to be good at explaining why you've made the decision you've made. You don't just make the call and move on. Right? We write opinions to justify why we've decided a particular way, how we've come to the conclusion that we've come to. And those opinions are important, and we spend a lot of time carefully crafting those opinions. And Justice Scalia, again, I was on a panel with him one time in a conference in Europe, and some of the European judges said, "Oh, Justice Scalia, you're such a wonderful writer. You must love writing." And of course, Justice Scalia, being Justice Scalia, is like, "I can't stand writing. It's painful. It hurts." And he said, "I love having written." Yes, indeed. Writing is painful. It hurts. Even the best, to hear that from Justice Scalia, I thought, oh, thank goodness. Because what that showed is even the best writers, it is a struggle sometimes to get the words onto the page to explain why you've decided a particular way. But it's so important. That process is a discipline to make sure we're deciding things the right way. And sometimes you'll hear judges say, it just wouldn't write. We often say that to each other, it just wouldn't write. We voted a particular way, it just wouldn't write. And that writing process is a discipline, again, to check us from deciding cases in an incorrect way, to decide them improperly. In the NFL, why are the referees mic'd up and explaining to the crowd? To explain, right? Ed Hockley, one of the famous NFL referees, he'll give you like a 4-part explanation of why they did. In A, we did this, and the pass was bobbled, and he was going out, and you hear this whole thing. That's good. Good explanation, right? He's a model for concise judicial decision-making, I think. In baseball, the umpires will try to explain the decision to the managers sometime. The managers, this does seem anachronistic, but the managers will come out sometimes and kick dirt on the umpires. Fortunately, in the courthouse, no one comes up and kind of kicks us, but that still happens in baseball. The duty of explanation, so important, I think, to being a good judge and a good umpire. To be a good judge and a good umpire, we have to strive for consistency. You hear this in sports so often too, which is just one consistency. Call it the same for both teams, right? You see someone get a charge call, and you see the coach yelling and pointing down to the other end of the court. What the coach is saying is call that down at the other end of the court as well. And so too for judges. I think it's important to be consistent within the game and across games, following precedent. So important for us to strive to be consistent in how we're deciding cases, how we're confronting issues, whether it be stare decisis, statutory interpretation. Consistency, a great virtue of something we have to strive for. And again, that's a check to be consistent. I decided the case yesterday on this basis. Well, today, the parties might be in different positions. Am I going to rely on that same ground today? The answer has to be yes, right? We have to be consistent in how we decide things, even though the parties may be flipped around, the issues may be flipped around. To be judges as umpires, it can't just be the judges who play a role in this. If we believe in this vision of neutral, impartial judicial decision-making and not just politicians in robes, Congress needs to help too in the federal system by drafting laws that are as clear as possible. And that's hard because Congress is a body of 535 people and they have to compromise. And it's hard to write clear laws. When you're in a courtroom or you're in litigation, you say, oh, Congress, they couldn't draft this law clearly. It's not because someone was incompetent for the most part. That's not why the law was drafted so confusingly or so ambiguously or so repetitively or with gaps in it. It's usually because the drafting process is a compromise. But to the extent, and compromise means sometimes they have to kick the can on certain issues, or they might have to be ambiguous about something that otherwise would benefit from clarity. But to the extent Congress can be clearer in statutes, to the extent Congress can follow at least some legislative drafting rules, and they've really improved tremendously on this with the legislative drafting shops that are in Congress over the last couple of generations. Congress can really do a service to this ideal, which I think is so important to our constitutional system, that judges are neutral umpires. Clear laws and clear rules avoid disputes. Now just think about, like for anyone who's a Packers or Cowboys fan, the Dez Bryant catch this year in the playoff game, right? There was all this debate. Was it a catch? Was it not a catch? Well, the rule had been drafted quite clearly, and the Cowboys fans won't like this, but it had been drafted quite clearly to cover that situation. It was not a catch. It was not a catch. Now, maybe the rule should be changed. Maybe Congress should change the laws sometimes, but the rule was quite clear because the NFL is actually pretty good at anticipating issues and responding when issues arise and drafting clear rules so that the next time it arises. They just drafted a new rule for those of you who are Patriots fans, and they did that play where they shuffled the players in and kind of confused the Ravens towards the end of the game in the playoff game. Well, the NFL just drafted a new rule. Guess what? Next year that's going to be illegal in the NFL. So they responded to that kind of thing. Congress can do the same thing. Congress does well when it can in improving statutes, but I think they could be more responsive when issues of ambiguity arise in court cases, when they learn of ambiguity in decision-making. Judge Katzmann, who's Chief Judge of the Second Circuit and a wonderful judge, has done a great job of trying to work with Congress when issues arise in the courts that show flaws, not partisan flaws, not ideological flaws, but just mistakes or issues that have arisen of confusion in statutes, informing Congress of those, and so that Congress can fix them in real time. That's important for the idea of judge as umpire as well. Now, the last thing I'll say about the judge as umpire is there are limits to the vision. We're not robots. One of the common critiques, oh, you think the judges are umpires, you're just robots. You're just doing mechanical decision-making, then is your vision. And that's not the vision, because there are areas of the law that sometimes entail discretion. And it's important not to deny that sometimes the law may require judges to exercise reasoned decision-making within a law that entails some discretion for how the decision is made. What's reasonable under the Fourth Amendment? There's a body of precedent that helps inform that, but what's reasonable under the Fourth Amendment? What is a compelling government interest under the Religious Freedom Restoration Act? Compelling government interest, that's all it says. What are you supposed to do with that as judges, right? Rule 501 of the Federal Rules of Evidence, that judges are supposed to devise evidentiary privileges in the light of reason and experience. How are we supposed to do that, right? That's not pure interpretation. Under the Sherman Act, unreasonable restraints of trade. How are we supposed to figure out what are unreasonable restraints of trade? In other words, there are areas of law where there are pockets of law where there is discretion written into the law, and then judges confront this situation where it's not purely interpretive. It's not just figuring out what the meaning of a term is. And there will probably always be some discretion in some areas of the law, and I think it's important as you articulate the vision of the judge as umpire to also recognize that as well, so that your vision is not caricatured as being every case is simply mechanical and robotic for judges, because not every case just comes down to pure interpretation. Now, even in those cases where there is discretion, it's important that we do those things that I mentioned, that we try to follow precedent and have a stable body of precedent, that we try to write our decisions in reasoned, in clear ways, that we be consistent in how we go about deciding like cases alike, that we do so candidly. This happens in sports as well. Issues arise in games that weren't foreseen by the rules, and the umpires or the referees have to make a decision on the spot. So too in judicial decision-making does that happen on occasion. So in closing, again, I'm honored to be here. I look forward to questions on these topics or any topic you may have until the dean shuts the mic off. And again, a great honor to be at this distinguished law school, great honor to be with the dean. Thank you all. I will vigorously defend the vision of judge as umpire, and I was happy to do so and honored to do so here today, and look forward to your questions. Thank you. Yes, ma'am.
Question. Would you talk a little bit about judge as office manager? How do you organize your office, and how do the panels get selected, and how do you interact with the other panel members to get the decisions organized?
Okay, so in terms of the staff we have, each judge on my court has 4 law clerks, and that's an important part of this as well, I think, because when I hire law clerks, I want them to push back on me. I might look at a case in a particular way, and I want law clerks, they're usually straight out of law school or a couple years out of law school, to push back on my inclination, to challenge my thinking on a particular case. I think that's, again, an important part of judging, is constantly re-examining your own decision-making. Like I said, I'm not, we all fall short. of this, and I would include myself. We all try and we all fall short, but it's important to keep striving, and I think law clerks are an important part of that. They help us with the research, they help us with opinion drafting, they help us tell us that draft opinion stinks, they help us tell us you're on the wrong track here given what the Supreme Court said on a particular issue. They're very important checks, I think, and aids. With the assignment of cases, it's a random assignment process. Computer spits out the names and the cases that are assigned to particular cases, and that's how that works. I think the idea there is to make sure that judges aren't picking the particular cases they want to be on. Again, we're passive in that sense. The cases come to us. We don't choose, well, this year I want to make a mark on Fourth Amendment law. No, that's not how we go about our business. We take the cases that come to us, we take the issues that come to us, and the random assignment is part of that. Then on working, you asked about working with the other judges. That's a critically important part of our system. I think our appellate system is, like I mentioned, collegiality, but we do draft opinions, we'll send them out to the other judges, and it's really important for the other judges to be comfortable with that opinion. Now, that doesn't mean word choice and paragraph structure and what have you. That's usually the personal domain of the authoring judge, but it does mean pushing back on things that they don't think make sense or where they have a disagreement, and we'll often have memos that go back and forth. I have trouble with that paragraph on page 12 and footnote 14 I don't agree with, and then we'll respond and go back. And sometimes that means the product is not as, I talked about Congress drafting laws, and there's compromise. Sometimes judicial opinions, if you read footnote in a judicial opinion and it seems incomprehensible, it could be because we screwed up, that's very possible, but it is oftentimes because there's compromise at work in judicial opinion writing too. Whenever I see something in the Supreme Court opinion that seems very ambiguous or confused, my first reaction to that is not because they're all so smart and on the ball, is not, oh, someone dropped the ball. It is, oh, to get to 5 votes on that particular case, they kind of had to compromise on what that said. So it's group decision making in that sense, and that's a very important part of the process as well. So the judge as office manager, I think the things that you have to do when I go to work any given day, the things that I'm doing with my clerks and with my colleagues, hopefully reinforce this ideal of trying to be impartial in how we go about our decision making. Back.
Yeah, hello, and thank you very much for coming. I wondered a bit about, I know judges must often and do talk about the merits of cases, and one of the things you discussed was that judges should decide cases according to the established rules of construction and begin with the text. So I wonder how often judges actually discuss methods of statutory interpretation, because one of the things that I love when reading some Supreme Court opinions, sometimes Justice Scalia will say, we've agreed on statutory interpretation 101, that there is a precise way we ought to go about doing it. How often do judges actually talk about methods as opposed to the merits of underlying cases?
So I think those discussions do occur, and then oftentimes it'll occur when judges, sometimes not in the judicial opinions, but when, like Judge Katzmann, Chief Judge Katzmann I mentioned, he has a new book out on statutory interpretation, which is very, very good and very thoughtful and discusses the methodology of statutory interpretation. Justice Scalia wrote a book called Reading Law with Brian Garner that is, again, a very important book on methodology. Agree or disagree with some parts of it, but it's very important in defining the issues, I think, or setting forth the issues that can divide judges. Does it happen? I frankly think it could happen more. One of the things I've talked about some in the past is I think we've made great strides in statutory interpretation as a system in recognizing, judges of all stripes, that the text is important. It's not the only thing, but it's very important. There used to be, I think, 30 years ago, a sense that statutory interpretation was much more the judges finding their way to what they believed was the just outcome. And that was that was dismissing Congress's efforts sometimes in drafting statutes. At least that was the critique that Justice Scalia came up with. But I think now the text is important, but then there are these canons of construction. Justum generis canon, or the constitutional avoidance canon, or the surplusage canon, or the Chevron doctrine. And you see this in cases like at the Supreme Court a couple weeks ago, this fish case about someone who had tossed away a fish and was prosecuted for obstruction of justice. And the question was whether a fish is a tangible object under this particular statute. That sounds easy to say, but it was a 5-4 decision with very vehement, very vehement dissent, not divided along the usual lines that the media thinks about when they think about the Supreme Court. Justice Ginsburg wrote the majority opinion actually plurality opinion for 4 justices. Justice Alito concurred in the judgment, and Justice Kagan wrote a passionate dissent that was joined by Justice Scalia, Justice Thomas, and Justice Kennedy. And so that's not the usual lines you see in divided 5-4 cases. I think at least that's the way the public often would describe it. And so I think what that showed was that we're not quite at the point on canons of construction that we have this agreement that has the established rules of the road that avoid the discretion. So one of the things I mentioned here was if we have better established rules of the road, whether it's Congress doing it or judges doing it, we avoid that inclination or that difficulty where we have to decide some hugely consequential case with disagreement about the methodology also lurking in the case. When you have agreement about the methodology, it makes it easier to decide the hugely consequential case in a way that's not going to divide along lines. So one of my things I think is important is for judges to keep working to do better. It's always you will never achieve perfection. We're constantly in search of doing better, and one of the things we can do better, I think, is get to a more agreed upon methodology for certain of the canons of construction and statutory interpretation. And I think that's an important project. Chief Judge Katzmann certainly advanced the ball on that. Justice Scalia has advanced the ball as well, and I think that's an important thing to keep in mind. And not to go too long-winded on your question, but another really hard thing as a judge is a lot of these canons turn on, is the text ambiguous? Okay, that turns out to be, is it clear? Then you just follow the text. Is it ambiguous? Then one of the canons of construction kick in. So there turns out there's no real guide to how do you determine whether it's ambiguous. As Ward Farnsworth, who's now the dean at Texas Law School, has written, ambiguity about ambiguity. And that turns out, I would say, in my experience doing a lot of statutory interpretation cases, that turns out to be a real sticking point in cases where there's division among judges, that some judges will read the text and think it's clear, and others will say no, and so we therefore have to apply constitutional avoidance or the Chevron doctrine of deference to administrative agencies or the surplus, whatever canon it might be. And that turns out to be complicated as well. Again, I don't think we'll ever eliminate that, but I think we can do better as a system in trying to minimize the number of cases that arise in that posture. Yes, ma'am.
So I had a comment and a question. My comment was just, I want to thank you for your remarks in general, but I really appreciate the concept of something not writing itself. I think it's a good reminder for our students about why we force them to do so much writing. But even in my own academic writing, for example, when something's not writing, it's usually a good alert to me that maybe the idea is
Right, yes, yes.
wrong. So
I sadly, yes, that happens.
I like that comment. I'll remember that. But my question was one I like to ask judges whenever I meet judges, which is, what's the hardest part of your job?
I think the hardest part of the job is deciding the case and writing the opinion in a way that reflects the closeness of the case, but also provides a decisive answer to the case, because you are setting forth a precedent that has to guide future behavior. In our court, lots of times administrative agencies or the people affected by what administrative agencies do. And so I'm sure I could give, and that's one of the hard things, I'm sure there are other hard things I could give you, but one of the things I sometimes fear is we tend to overwrite. So we write a majority opinion like this, by the time we're done, it's like 99-1, the issue. And it may be a 51-49 issue at oral argument in a conference, and then we get writing, we get wound up. It's like, oh, yeah, and the opinion comes out, and I think people think, wow, that was really an easy case for them. And sometimes we don't do a good job, and I don't do as good a job, I think, of reflecting the uncertainty. At the same time, if you overdo that, you sometimes diminish the force of the precedent that you're setting in a particular case. And so I think just finding the right balance between uncertainty about how to decide and setting forth a clear, decisive precedent in a particular case is really hard. I'm going to now elaborate on the answer because there are other answers. Knowing that your decisions have big consequences. In some cases, I'm not going to overstate our role, but it is true that some of our decisions have significant consequences, whether it's a one-off criminal case with a criminal defendant, huge consequences for one person, that's huge consequences, or it could be an environmental case that has huge consequences for lots of industries and lots of people and people who want clean water and clean air and so on, and so there are huge consequences in particular cases. And so I think it's hard sometimes to know that you're making a decision with significant consequences, but you can't freeze up, you can't worry about that in the end. You just have to be cognizant of those consequences and to, I think, put yourself in the shoes of the people who are affected by the particular case and to understand their legal arguments as best you can. And I think that's the way you get through those cases that are challenging cases with big consequences, is to follow the discipline of going through the methods that I tried to describe here today, the discipline of writing it out, working with your colleagues, and trying to do that. But still you feel uncomfortable sometimes. I do. I know my colleagues do. You feel uncomfortable sometimes with the effects of your decisions. And knowing if you're being a good judge, that means sometimes you're doing something that you really don't like the result in the sense of the implications for the particular people, but you are following the law. That's part of being, I think, a good judge, but that doesn't make it pleasant, and I think that makes it difficult sometimes to deal with. Now, you can, I think it's appropriate, and I've done this before, to write in the opinion that you're not super pleased with the consequences of the decision, but you think that's what the requirement of this case is for a judge deciding it neutrally and impartially, and I think that's a fine thing for judges to do. In fact, in that Fish case that I mentioned, Justice Kagan in her dissent said that the prosecution, the conviction should be upheld in that case, but at the end of the opinion, she wrote about having said all of that, about why the law compelled that in her view, she recognized that this case was a symbol of over-criminalization in the federal criminal code and excessively harsh sentences in particular cases. And so I thought that was and she actually pointed out that was something that's appropriate for judges to say, and I think that's right for judges to recognize that they may not love the consequences of particular cases, but they have to do it that way. Yes, sir.
Well, thinking and considering consequences and considering consistency, I was wondering if you could just speak to the en banc process. You mentioned panels, such that two judges may speak for the circuit, and in other circuits, one of those two judges may be a visiting judge, might even be a district court judge. And just what's your thoughts in terms of the en banc process and frequency or infrequency of which?
So the en banc process is where the full court rehears the case that might have been decided by the three-judge panel, and on our court there are 11 active judges now. And so it's used sparingly. The rule says it should be used in cases of exceptional importance. And of course, that's sometimes in the eye of the beholder, what's a case of exceptional importance. And a factor that I think goes into it for some judges in some cases is how wrong do you think the panel decision really was? So how important is it in terms of maybe consequences affect some people? How important is it legally? And how mistaken do you think the panel decision might have been? I think those are things you factor in. But it's used sparingly. It's used sparingly in our court. Other courts use it more often. The Ninth Circuit, which has, I think, 28 or 29 active judges and is a sprawling circuit and has a lot of visiting judges and a lot of panel disagreement, they use the in-bank process quite a bit in the Ninth Circuit. And I clerked on the Ninth Circuit for Judge Kaczynski, who was an active proponent of using the in-bank process to correct mistaken panel decisions. And so I think it's different with different courts, different cultures of different courts. Ultimately, I think it's difficult to use it too much because it takes a lot of resources for the court to go in bank, and the in-bank cases take a lot of time, a lot of negotiation. You exponentially multiply the difficulty of getting agreement on a particular footnote. Justice Sotomayor, one of the things she says about being on the Supreme Court as compared to being on the Second Circuit is every case is an in-bank on the Supreme Court. In other words, it's challenging to get 9 people moving in the same direction on the Supreme Court, so too on the lower courts when you have an in-bank with 11 on our court or whatever the number might be on the other courts. It can be a challenge to do it. So I think it's got a place, and I certainly have voted for in-bank a number of times and sometimes write dissents from denial of rehearing in-bank. Sometimes opinions I've written have been in-banked by other judges. And so that happens, but I think it's used sparingly, and I think that's a wise use of the in-bank process. Yes, sir?
What role does natural law play in the judicial philosophy of the judge's umpire?
And how would you define natural law?
Basically, something outside of the text of the traditional legal structure.
Right. So I think, that judges are deciding cases based on the law, and natural law is some external philosophy or philosophical principles to what the law in a particular case might say, the statute, the precedent, the legislative history, whatever you're looking at in a particular case. And so I think natural law is often, in this context, it's usually a term associated with bringing your own personal philosophical views to bear on how to decide a particular issue. And again, I don't think that's really consistent with the idea of the judge as umpire in a ordinary case or even in an extraordinary case. I think the idea is to decide the cases based on the established principles and established rules of the road that judges have before them, and try to avoid bringing your own philosophical predilections to bear in a particular case. And so I think that's how I would address that. I think that's come up before with other judges who get questions about the role of natural law, the role of their own personal predilections. And again, judging at its best, I think, is figuring your way through a complicated statutory regime following established rules of the road to reach an answer that is impartially derived as best you can using those tools of construction. Yes, ma'am.
I've got a follow-up on what you said a few minutes ago. You mentioned a couple of times evolving role of statutory construction and sort of emerging consensus is too strong, I guess, but an emerging direction for statutory construction. And a couple minutes ago, you alluded to the culture of each circuit being a little bit different. How is that culture formed? Is it happenstance of the people who are appointed to that circuit, or does the chief judge say we're all going to do workshops on Thursday afternoons, or
Yes.
say, hey, I'm an Article 3 judge, whatever.
Right.
I'm not going to do it.
I think it's the luck of the people who happen to be appointed to a particular court, and needless to say, like in any institution, the people who've been there for a longer period of time try to instill the norms of that circuit to the newer members, sometimes successfully, sometimes not, but that's how that transpires. I would say the chief judge has a role that comes from seniority, not from the title of chief. In other words, the role from being there for a long time, being able to speak to, well, this is how we did it. Of course, newer judges are wont to say, well, why are we doing something this way? And just because we've always done it that way is not a sufficient answer sometimes. And sometimes that's good. Newer judges will come on and bring a fresh perspective on something that you think, you know what, that is screwed up. Why are we doing it that way? And so I think that's a good thing to have new blood constantly on the courts. But I think that culture just develops through as in most institutions, through the luck of who happens to be in the particular seats at the particular time. I don't think there's any way to force it from above, so to speak, as the chief, for the chief judges of the circuit, other than how persuasive they are and what they say.
Do you ever think, wow, I wish I'd gotten on the 9?
No. No, I never say that. Except I did sit by designation on the Ninth Circuit a couple years ago, and that courthouse in Pasadena is awesome. So that would be a good part of that gig. Dealing with all the in-bank memos, not so much. But the view out over the Rose Bowl. You had a question up there?
When you're talking about the culture of the court, do you find that there's a common characteristic among judges that were selected to be on the court that make them very successful and were appointed by the president to?
Yes, how to become a judge. That's so in the federal system. For DC is different. For all the other federal district courts and courts of appeals around the country, the home state senators play a huge role. So to become a judge in Wyoming or Texas or Florida or South Carolina, knowing a senator in that state is often very important, or having such a reputation within the state that the senators would have heard of your reputation within the state can be very important. They play an often unseen but outsized role in which judges are named in particular, especially at the district court level in the states. DC is different because we don't have the home state senators, and I think our court is an example of a couple things. A national court, we're come from all over the place. We have a former justice of the California Supreme Court, former district judge in North Carolina, former district judge from South Carolina, someone who was in Utah before being named to the DC circuit. So we have people who've come from around the country. We also have a lot of people who have experience either in the Justice Department or on the Hill on our court, which makes some sense, or in the executive branch at least of the government, or on the Hill with some legislative experience, which makes sense both substantively because we have so much administrative law, and so knowing something about that makes sense, and also makes sense in terms of the realities of the appointment process, because you have to become known to the people who are doing the picking at some point in some way, and working in one of those positions can often assist with that. But just generally, you're thinking about your next job or the job after that or the job after that, one of the things I always say to students is, in DC in particular, everyone's always like, what's my next job? What's my next job? And the best way to get the next job is do really well at the current job. And so that's really important for people starting out in their careers, because I think oftentimes the initial jobs in your career are not your ultimate aspiration. In fact, rarely is the initial job in your career the ultimate aspiration, but it's important not to treat any job other than with the utmost, as it's a job of the utmost importance, and to do your best at it. And that's really important as you go through your career, I think, in anything you're going to do. And something I see constantly, and you see it in Washington, but everywhere, someone who thinks a summer job at a firm's not a big deal, and they kind of don't do such a great job in a particular memo, like 10 years later, the partner will remember that. That person did a bad memo, that kind of thing happens. And so just doing your best at whatever your task is at a particular time is a really important thing, no matter what your ultimate aspiration might be. One more. Yes, go ahead.
Can you discuss the importance of changing your mind, or being willing to change your mind as a requirement for being a good judge? And I'm just curious to know, going from law school, learning how to think like a lawyer, to then learning how to think like a judge, standing for justice versus standing for fairness, kind of like what kind of process is that like to change your mind, and can you really become impartial after all those years, all those experiences?
That's a great question, and that's one of the dangers, I said, of being there for a long time, is you become more sure of yourself in some respects, and that can be good in some respects, but it can be bad in some respects. So I think it's just constantly reminding yourself that just because you said it once doesn't mean it's right, and to constantly re-examine. You don't want to be doing this in every case, and nor would it happen in every case, but to be willing to, when someone says, someone writes a law review article that says that opinion's really, really messed up and really missed a key point, to be willing not to just dismiss that, but to think about that, I think is a really important aspect of being a judge, and something that can be painful. It's painful. It's more painful now. When judges 20 years ago, it'd be a law review article that'd come out 2 years later that would say, oh, they missed the boat. Now it's a blog post like 20 seconds later. It's like, they totally missed it. And that's a little frightening. You try to avoid writing an opinion that's going to be subject to those kinds of critiques. But I think it is important but hard to be willing to change your mind when you realize that either you're thinking about something differently, or facts on the ground have changed, or the legal environment's changed in some way, to be doing that. And again, I would say that in whatever line of work you're in, not just judging, but being willing to re-examine your premises and re-examine your conclusions when the evidence may prove that your initial view of something might have been ill-founded.